Welcome to the debate. Today, we're diving into, well, one of the most persistent and, frankly, complicated legal challenges in the global labor market. How do we correctly distinguish between genuine self-employment and what's often called disguised employment? We're focusing particularly on the Italian legal framework, where the rise of the falso autonomo, the false freelancer, is really eroding fundamental worker rights.
It's absolutely a critical challenge because the whole protective framework of labor law, things like, severance pay, sick leave, unemployment insurance, all of that, it really hinges entirely on correctly classifying that work relationship. The stakes are just immense, both for the worker's economic security and for the employer's potential liabilities down the line.
Exactly. And our source material highlights how the judiciary struggles to apply the Principio di Effettività, this idea that substance has to prevail over the form the contract's label in these kinds of ambiguous cases. So the core disagreement we're tackling today is this. When a court looks at a potentially disguised employment relationship, which indicators should really carry the most weight, especially in today's, very fluid labor market? My position is that we have to prioritize the functional elements of dependency, specifically the presence of organizational integration, what the Italian law calls eteroorganizzazione, and also the absence of genuine economic risk for the worker.
Okay. I understand that push towards looking at the functional reality. I do. But I come at it from a slightly different angle. While the Principio di Effettività absolutely must apply, the legal definition of subordinate work, lavoro subordinato, it's fundamentally rooted in these classical legal structures. Therefore, I argue the core legal test must still hinge on the explicit traditional indicators derived from the three classic powers of the employer. That's the power to direct, the power to control, and the power to discipline the worker. These powers, they've been enshrined in law since 1942, and they remain the established criteria for defining legal subordination.
Okay, I see why you emphasize those historic powers, but well, the reason I think we need to prioritize these functional elements, like organizational integration and economic risk, is precisely because the rise of this disguised employment is often driven by employers consciously trying to, let's say, exploit the boundaries of those traditional definitions, usually for cost reduction. So relying solely on the formalities of the three classic powers, it often fails to protect workers from the very real loss of fundamental rights, especially when employers use, clever contractual phrasing.
I certainly acknowledge that market pressures push many collaborations into this kind of gray zone. That's undeniable. But legal precision here is paramount. My position is essentially that the legal definition of subordination, Article 2094 of the Civil Code, it hinges fundamentally on the explicit exercise of those three classic powers. Now, indicators like having fixed work hours or using company equipment, sure, they're important warning signs, campanelli d'allarme as the sources say, but they're only relevant insofar as they demonstrate the employer's direct operational control over the means of production, how the work is done. If a professional genuinely maintains autonomy in how, when, and where they accomplish the task, even if they are highly dependent economically on one client, then the core legal requirement for subordination, which is that right to command, it's simply not met in my view.
Right. Well, that brings us immediately to our first real point of contention then. The sufficiency of those classic three powers when faced with, modern masking techniques. You're asserting that direction, control, and discipline are the pillars, the pilastri dell'intera direzione, and they're the only truly reliable way to distinguish a contract for genuine self-employment from a dependent one.
Exactly. These powers are the specific legal mechanisms that effectively strip the worker of their organizational freedom and legally bind them to the enterprise's directives. Without concrete demonstration that these powers are actually being utilized, the relationship remains one focused on delivering a specific result, which implies autonomy, not submitting to the detailed process and means of execution, which implies subordination.
That's a compelling argument based on legal tradition, I grant you. Though I'd frame it differently considering how sophisticated contract drafting has become. We really have to confront this issue of what our sources call clausole di stile, boilerplate clauses. These are contractual formulations that explicitly assert the worker has full organizational and managerial autonomy, even when the day-to-day operational reality is the complete opposite. If we adhere strictly to needing proof of an explicit, formal exercise of direction or discipline, well, those cleverly drafted contracts can make the three powers seem virtually invisible, at least in the formal wording.
I'm sorry, but I just don't quite buy that the contract wording itself can permanently mask the reality. The courts have, well, always looked beyond the name given to the contract. The judge's task is to evaluate the concrete execution of the relationship. If an organization uses standardized procedures, which, let's face it, is common across many professional services today, that doesn't automatically confer the legal power to direct. The worker still needs to demonstrate that they were, for example, sanctioned for deviation, or that their working time was rigidly dictated, regardless of what the contract says. The evidence of subordination has to be behavioral, not just semantic, you know?
Okay, but what if the evidence of subordination is now manifested more subtly through, say, complete organizational integration, like using the company email signature, a company ID badge, maybe mandated attendance at non-task specific company meetings, being inserted fully into the client's IT system and internal comms? If it works like that, it places, I think, too high a burden on the worker to prove an explicit sanction was issued or a direct order was given about how to do the work. This deep organizational insertion, this eteroorganizazione, is often the most revealing functional index today, which I think brings us naturally to the economic reality of the situation.
That is an important transition, yes, because the relationship between that organizational integration and economic vulnerability is definitely key.
Precisely. So I'd argue that the absence of economic risk for the worker, coupled with an intense reliance on a single major client, what the Italians call monocommittenza, especially where the worker bills, say, over 80% of their income to one source, this fundamentally negates the core purpose and definition of self-employment. The genuine entrepreneur, the autonomo, is supposed to bear the risk of enterprise, right?
Monocommittenza is certainly a strong factor. I agree. It's a definite red flag that should trigger and does trigger judicial scrutiny. No question.
But I'd say it's more than just a red flag. It's often a powerful, practical index of functional subordination. When the worker effectively bears zero operational risk, they have no significant cost of management. Maybe their compensation is essentially guaranteed regardless of the final outcome of the project, and all the major investment decisions are taken by the client. They lose any genuine entrepreneurial status. This kind of total economic dependency, it negates that foundational element of risk. The worker might have a Partita IVA, a VAT number, sure, but they aren't really operating a business in any meaningful sense. They're functioning more like a cost center for the client.
That's a compelling argument regarding the worker's vulnerability, absolutely. But have you considered the counter-argument that extending the scope of subordination based purely on these economic metrics risks sweeping in genuine high-level professional practice? Think about it. Many highly skilled IT professionals, specialized consultants, or engineers might legitimately invoice 80% or even more to one major client for years, simply because the project they're engaged on is large, complex, and inherently long-term.
But in those cases of genuine self-employment, the professional still retains meaningful control over how the deliverable is produced, wouldn't you say? The methodology, the tools, perhaps?
Exactly my point. If the professional retains true autonomy over the methodology, the specific timing beyond broad deadlines, and the scheduling of how they execute their tasks, even if they are heavily reliant on that one large contract for their income, the core element of legal subordination, that power to command the process, is still missing. If we simply equate high economic dependence with legal employment status, we risk, I think, overextending labor protections into what is legitimately an independent professional relationship. We must still be able to demonstrate the client's potere direttivo, that specific right to tell the worker how to do the job, not just what result is needed.
But the relationship between that economic reality and the organizational control has become almost inseparable, hasn't it? Especially when we look at the evolution of digital platforms. Consider the landmark rulings regarding delivery riders in the gig economy. Here, the courts were really forced to grapple with a type of control that wasn't administered directly by a human manager.
Right, you're referring to the rulings on algorithmic management. Yes, those are highly significant, I agree.
Yes. And the court recognized that algorithmic control, things like geolocalization tracking, performance rating systems, and even immediate sanctions like account deactivation, based purely on metrics, this acts as a powerful, modern form of both the disciplinary and the directive power. The algorithm, it's not some neutral piece of code. It clearly reflects deliberate business choices made by the platform owner, choices that enforce organization and compliance on the workers.
I absolutely agree that the ruling correctly identifies that technology is changing the mechanisms of control. That's clear.
I would argue it goes a bit further than just the mechanism, though. It sort of proves that eteroorganizzazione, the organization of the worker's activity by the client, even if it's done through digital means, is arguably the most relevant index we have today. The technology allows for this incredibly deep functional integration, often without requiring an explicit traditional chain of command. The worker becomes bound by the system itself, proving functional dependence, regardless of what the autonomy clauses in their contract might say.
Okay, I acknowledge the power of the platform to control, definitely. However, I don't quite buy the argument that the algorithm constitutes an entirely new type of legal test, somehow independent of the classical powers. I read the ruling as confirming that this new technology is simply a highly efficient means through which the employer exercises those core legal powers, direction and control. For the writer to succeed in court, they still needed to demonstrate that the mechanism, the app, imposed standardized operational methods and a strong technological constraint that effectively restricted their personal freedom and scheduling autonomy.
But doesn't that almost reinforce my point that perhaps the only way to detect the real exercise of those core powers now in many modern contexts is by focusing squarely on that organizational dependency? In many modern workplaces, the organizational reality, like being integrated into the client's email system, having fixed rotational shifts assigned, mandatory participation in internal training, it often precludes any real day-to-day autonomy, regardless of whether a manager explicitly issues a daily direction in the old sense. When the worker is inserted that seamlessly into the client's production structure, they are functionally dependent. And that functional reality, I believe, must govern the legal classification if we're serious about upholding worker protections.
The judicial process, however, still demands clear, substantive evidence of that command element to fundamentally alter a relationship's legal status from autonomy to subordination. To justify stripping away the autonomy inherent in the self-employment model, the courts, based on precedent, still require the demonstration of those classic legal pillars. We cannot, I think, allow the valuable distinction between genuine self-employment and dependent work to be eroded simply because economic dependence happens to be high in a particular case. The burden of proof, rightly or wrongly, still rests on proving the employer's right to command, not merely demonstrating the worker's economic necessity or integration level.
Ultimately, I maintain that the functional reality of dependence and deep organizational integration has to govern the legal classification, especially where we see evidence that employers might be exploiting contractual loopholes primarily to evade the costs and, frankly, the responsibilities that come with fundamental worker rights.
And while we absolutely recognize that functional reality is crucial evidence, the established judicial process still requires the clear demonstration of those classic legal pillars, direction, control, and discipline, to justify legally redefining the nature of the work from autonomous to subordinate.
It seems the Principio di Effettività forces the courts into this constant, very challenging balancing act then.
Indeed it does, and the necessity of weighing all these diverse indices together, the formal contract versus the practical, day-to-day behavioral signals, the economic reality, the organizational setup, that remains the fundamental challenge, especially in upholding the protective hierarchy of labor norms in what is undeniably an increasingly complex and digitally mediated world of work. There's clearly much more to explore in how these different indices interact and should be weighted.